Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If, for whatever reason, during any point in this proceeding, you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
Mr. Mio is back, and this time, he's about to learn the hard way why having legal representation isn't optional, it's essential. If you're new here, this is part 2 of a case we covered earlier, and let's just say, Daniel Mio has earned his reputation as one of the most arrogant and clueless defendants to ever face Judge Simpson. From the moment he walked in, it was chaos, chewing gum in court, refusing to answer questions, acting smug and untouchable. But reality hits fast in a courtroom, and Judge Simpson isn't the type to tolerate disrespect. So, let's dive straight into the action and watch Mr. Mio's ego collide head-on with the power of the law.
And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping to sort of reconcile both of those things as whether or not discovery is complete, the defendant's prepared to move forward, and if he ever intends to file a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Gu, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, We will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the 2nd.
We could try for the 2nd, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
This man is the perfect example of why you should never walk into a courtroom without legal representation. From the start, his smug attitude and reckless confidence made everything worse. He tried to outsmart Judge Simpson, acting like he was above the law, a move that backfired instantly. His behavior mirrors that of a sovereign citizen, defiant, arrogant, and completely detached from reality. Facing serious charges for assaulting a police officer, and even losing custody of his child, he treated the entire hearing like a joke, as if nothing was at stake. But this wasn't just another day in court. This was his life unraveling. Instead of seeking help, he chose pride over reason, turning the judge, and everyone watching, completely against him. His case is a harsh reminder that representing yourself in court rarely ends well. Without proper counsel, you're not proving your intelligence, you're digging your own grave. So, let this be the lesson: respect the court, get legal representation, and don't let arrogance destroy your future. If you found this breakdown eye-opening, like, subscribe, and stay tuned. The next hearing in January promises to be even more unbelievable.